What if I told you that some of the bills piling up on your kitchen table, you never had to pay in the first place? It sounds unbelievable, but for many seniors, that's the shocking truth. Month after month, you open envelopes with numbers that make your stomach drop. You start worrying about how to stretch your Social Security check, which medications you might skip, or whether you can keep the lights on. I understand how heavy that burden feels, and you are not alone in it. In this video, I'm going to reveal 6 types of bills that seniors over 65 are often told they must pay. But legally, they may not owe a single penny. Knowing this could protect your savings, bring you peace of mind, and save you thousands of dollars. Stay with me until the end, because each point comes with practical steps you can take right now. Before we get started, I want to hear from you. Where are you watching this video from, and what time is it right now? Let me know in the comments. Even if it's just an ordinary moment in your day, I'd be honored to share it with you. And if you find this content helpful, don't forget to hit that subscribe button so you never miss the next important tip. Type 1. Medical bills not covered by insurance. Imagine this. It is late at night and you suddenly feel crushing pain in your chest. You call 911, the ambulance rushes you to the nearest hospital, and everything moves in a blur. You are grateful to be alive, but a few weeks later, a thick envelope arrives in the mail. Inside is a bill for thousands of dollars from a doctor whose name you do not recognize, a doctor you never remember meeting. The shock hits hard. You think to yourself, how could this happen? I have insurance. Shouldn't this be covered? So, for many older Americans, this is not just a rare nightmare. It is an all too common reality. Even with Medicare or private insurance, you can end up being billed for care you never agreed to or from providers outside your network. This is where the No Surprises Act, a law passed in the United States, comes in. It protects patients from many types of unexpected medical bills, especially for emergency care and for situations where you are treated at an in-network hospital by an out-of-network professional. In simple terms, if you had no choice in who treated you, the law says you should not be stuck with that extra bill. Let me share a real example. A retired teacher in Ohio fell in her kitchen, broke her hip, and was taken to the closest hospital. She had surgery, recovered, and thought everything was handled by her Medicare plan. Then came a $4,800 bill from an anesthesiologist she had never met or chosen. Because her care happened during an emergency and at an in-network facility, the bill was considered a surprise charge and was eventually dismissed under the No Surprises Act. Without that law, she might have been forced to pay money she did not owe. Still, even when a bill seems legitimate, insurance companies sometimes deny coverage for reasons that have nothing to do with your actual care. Sometimes it is a simple coding error. One wrong number in the system that marks a covered procedure as something not approved. Other time, it is because of missing paperwork, like a referral that was not sent in on time. And sometimes, delays or mistakes in their own process lead to wrongful denials. None of this automatically makes the bill your responsibility. That is why you should always slow down and review every medical bill carefully before paying. First, ask for an itemized bill, one that lists every service and every charge separately. This allows you to spot errors, like being billed twice for the same test or charged for something you never received. Second, ask whether the care was pre-approved by your insurance, and if not, whether it should have been under emergency rules. Third, confirm whether every provider involved was in-network. Even if one person was out of network, if you did not choose them, you might still be protected under the law. If you find mistakes or questionable charges, do not be afraid to appeal. Contact your insurance company in writing, explain the issue, and include copies of your medical records or any authorizations you have. You can also ask the provider to show proof that you agreed to the charges in writing. If they cannot produce your signature or clear evidence of your consent, you have strong grounds to negotiate the bill down, or have it dismissed entirely. Remember, these steps are not about avoiding legitimate bills. They are about making sure you do not pay for someone else's error or for services you never agreed to. As we age, every dollar matters. You worked hard for your savings, and protecting it is part of protecting your independence. It can feel intimidating to challenge a hospital or an insurance company, but you have rights and legal protections on your side. If you ever feel unsure, reach out to a senior advocacy group or a local legal aid service. They can guide you through the process and even handle communication on your behalf. Medical bills can be overwhelming, but they do not have to control your peace of mind. By knowing your rights, asking the right questions, and refusing to pay for unfair charges, you take back the power in a system that often feels stacked against you. And that, my friend, is a step toward keeping both your health and your finances in good shape for the years ahead. Type 2. Debts from a relative's account. Picture this. You are sitting at your kitchen table, sipping your morning coffee, when the phone rings. The voice on the other end is firm, almost cold, telling you that you owe money on an account. But the account belongs to your late husband, wife, or even your adult child. In that moment, your heart sinks. Grief is still fresh, and now you are being asked to pay for something that was never yours. It feels unfair, and it is. Here is the truth that many older Americans do not hear often enough. You are not automatically responsible for someone else's debt, even if they were your spouse, parent, or child. Unless you co-signed the loan or credit card, the law does not require you to pay it from your own savings. This means that if your name is not on the original agreement, that debt is not legally yours to settle. Yet, companies sometimes blur those lines. Take the case of an authorized user on a credit card. Many people believe that if they were listed as an authorized user, they share responsibility for the debt. That is not true. Being an authorized user means you were allowed to use the account, but the financial obligation remains with the primary account holder. Credit card companies know this, but some still make phone calls or send letters designed to confuse grieving families. I remember one story from a retired widow in Arizona. Her husband had passed away, leaving a credit card balance in his name only. The company sent her a letter saying the estate owed the money, but the language made it sound like she personally owed it. Wanting to do the right thing, she sent in a payment from her checking account. Only later, after speaking with a legal aid attorney, did she realize she was never required to pay from her own funds. That payment could not be recovered. So, how do you protect yourself from these situations? The first step is to always ask for proof. Request a written statement showing the debtor's name on the account and a copy of the original agreement. If your name is not listed as a co-signer, you have strong legal grounds to refuse payment. Do not agree to pay just to make the calls stop, because once you make a payment, you could unintentionally give the company leverage to claim responsibility. Second, understand that debts after death are usually handled through the person's estate. This means the executor or administrator of the estate uses the deceased person's assets, not yours, to settle any valid debts. If the estate has no money, many debts simply remain unpaid, and creditors cannot come after your personal savings, Social Security, or retirement accounts. Third, protect your emotional health. Collection calls, especially during a time of grief, can feel overwhelming and even frightening. Take the calls in writing if possible, and remember that you have the right to request all communication be done by mail. This gives you time to think, gather documents, and consult with someone you trust before responding. The truth is, companies count on confusion and emotional pressure to get payments they are not entitled to, but knowledge is power, and in this case, it can also protect your financial well-being. If you find yourself facing these calls or letters, pause, breathe, and remember, you have rights. You do not have to sacrifice your own stability to cover someone else's obligations. By asking for documentation, insisting on clarity, and letting the estate handle legitimate debts, you not only protect your money, but also your peace of mind. And in these years of your life, that peace is worth just as much as every dollar you save. Type 3. Personal loans without a written contract. Imagine this. A close friend from church, a kind neighbor, or even a distant cousin once lent you some money during a rough patch. Maybe it was a handshake deal after Sunday service, or just a quick agreement over coffee at the kitchen table. At the time, you trusted each other. There was no paperwork, no formal contract, just words spoken with the belief that friendship was stronger than signatures. Months or even years later, that same person comes back saying you owe them money, perhaps more than you remember, and suddenly it feels like the trust you shared has turned into pressure. In legal terms, this type of arrangement is called an unsecured loan without a written contract. Unsecured means there was no collateral, no house, car, or property put up to guarantee repayment. Without a written agreement that clearly outlines the amount, the repayment schedule, and the interest, if any, it is extremely difficult for the lender to prove in court that you are legally required to pay. Verbal agreements can sometimes hold weight, but they are notoriously hard to enforce because memories fade, details change, and it becomes one person's word against another's. Courts place the burden of proof on the lender. That means they must show concrete evidence that the loan existed, that you agreed to repay it, and under what terms. Acceptable evidence might include a signed promissory note, bank transfers labeled as loan, or written messages that spell out the agreement. Without these, it is often impossible to make the case stick. For seniors, this protection is important. It prevents false or inflated claims from turning into financial threats. I once heard about a retired couple in Michigan who gave a younger neighbor a ride to work for several months. They thought of it as a neighborly favor, happy to help someone starting out. A year later, the neighbor claimed they had promised to pay for gas every week and accused them of owing hundreds of dollars. There was no proof, no written record, but the accusations created tension and stress. In another case, a man gave his niece a graduation gift of $500, but later, when money got tight, he tried to claim it was a loan and demanded repayment. In both cases, the absence of a written agreement protected the recipients from having to pay money they did not truly owe. So, what should you do if someone insists you owe them for an old, unwritten loan? First, stay calm and ask for proof. Politely request any documents or records that show you agreed to repay, how much, and on what schedule. If they cannot provide that, the law is generally on your side. Second, do not let guilt or emotional pressure push you into paying something you do not legally owe. As we get older, our natural desire to avoid conflict can make us more vulnerable to this kind of manipulation. But paying just to keep the peace can sometimes open the door for further demands. Third, if you feel overwhelmed or threatened, reach out to a legal aid office or a senior advocacy group in your community. They can explain your rights in plain language, help you respond appropriately, and even handle communications on your behalf. Many of these services are free or low cost, and they exist to protect people just like you. Life is too short to carry the weight of debts that do not belong to you. Friendships and family connections should be built on trust and respect, not shaky promises and vague memories. By standing firm, asking for proof, and getting help when you need it, you can protect both your finances and your peace of mind. At this stage in life, your focus should be on your health, your comfort, and the people you love, not on defending yourself from unfounded claims. You have earned the right to live free from unnecessary financial stress, and knowing the law is one of the best tools to make that happen. Type 4. Utility bills for services you didn't use. Picture this. You have just moved out of your home to live closer to family, or perhaps you have settled into an assisted living community where your utilities are included. Life is changing, and you are adjusting to a new chapter. Then, a few weeks later, a bill arrives from your old electric company for hundreds of dollars. You know the service was shut off before you left, yet here it is. A charge for electricity you never used. For many older Americans, this is more than just an inconvenience. It is a source of stress and frustration, and it can make you feel powerless. You may even question yourself, wondering if you forgot to do something before you moved. But often, the problem is not you. It is the utility company. Sometimes they fail to record the final meter reading when you cancel service. Other times, they accidentally keep billing you for the property even after a new tenant has moved in. And in some cases, the bill might include charges for the new occupant's usage, simply because the system never updated the account. I remember a story from a retired couple in Pennsylvania who moved into assisted living. Before they left their home, they called the power company, canceled their account, and even wrote down the final meter reading. A month later, they were shocked to receive a bill for $600. The company claimed it was a late adjustment for past usage. But after an investigation, it turned out the meter had never been read correctly. Thankfully, the couple had their cancellation confirmation in writing, which allowed them to dispute and erase the bill. This is why keeping written proof is so important. Always ask for a service termination confirmation when you close a utility account. It might be a letter, an email, or a receipt with the date your service officially ended. That piece of paper can be your strongest defense if a company later tries to bill you for usage that happened after you moved. If you receive a suspicious utility bill, your next step is to request detailed documentation. Ask the company to provide the meter number, the dates the readings were taken, and the exact period of service you're being charged for. Compare those dates with your move-out date or the date you entered assisted living. If they do not match, you have a clear argument for removing the charges. Sometimes, despite your best efforts, the company may send the bill to a collection agency. If this happens, do not panic. You still have rights. Send a written dispute letter to the collection agency stating that the charges are incorrect and requesting verification. Under consumer protection laws, they must stop collection efforts until they provide proof of the debt. This gives you time to gather your records and respond with confidence. These situations can be emotionally draining, especially when you are trying to focus on your health and adjusting to a new living arrangement. The thought of fighting a large company can feel exhausting. But remember, you are not asking for special treatment. You are simply standing up for what is fair. You should not have to pay for someone else's electricity, water, or gas just because of an administrative mistake. By keeping good records, asking for proof, and calmly challenging errors, you protect both your finances and your peace of mind. You worked hard for every dollar in your retirement, and no one should be able to take that from you through a billing error. In the end, this is about more than a utility bill. It is about knowing that you have the right to question charges, the power to demand proof, and the ability to walk away from unfair demands. And when you do that, you are not just protecting your wallet, you are protecting your independence. Type 5. Old debts beyond the statute of limitations. Imagine answering the phone one afternoon and hearing a collector's voice telling you that you owe money on an account from decades ago. They might say it was a credit card you used in 1999 or a store account you completely forgot about. The shock sets in, followed by confusion. You wonder if you somehow missed a payment all those years ago, or if this is even real. For many seniors, this kind of call feels like a storm arriving out of a clear blue sky. In reality, much of this debt is what the law calls time-barred debt. That means it is too old for a creditor to sue you for payment. Every state in the U.S. sets its own statute of limitations, the legal time frame for filing a lawsuit over unpaid debt. For most unsecured debts, such as credit cards or personal loans, that period is usually between 3 and 6 years from the last payment you made. Once that time is up, the debt still exists on paper, but the creditor loses the legal power to take you to court and force payment. Here's an example that happens more often than you might think. A man in Florida received a letter saying he owed $2,300 on a department store card from the late 1990s. He had no records from that far back, and the account was long closed. After checking with a legal aid office, he learned the statute of limitations had expired more than 15 years earlier. The debt was time-barred, meaning he could not be legally forced to pay it. Without that knowledge, he might have given in to pressure and sent money unnecessarily. One of the biggest traps to watch for is the restart of the statute clock. If you make even a small payment, sometimes as little as $1, or if you admit in writing that you owe the debt, you may reset the time limit entirely. That gives the creditor new legal power to sue, even if the original debt was too old before. Collectors know this, and some will encourage you to just make a small good faith payment without explaining the consequences. So, what should you do if you are contacted about an old debt? First, do not agree to anything right away. Instead, request a validation letter from the collector. This letter should confirm the original creditor, the amount owed, and most importantly, the date of your last payment. That date determines whether the statute of limitations has expired. Second, avoid admitting you owe the debt until you have verified all the details. A simple, "I'm not sure what this is better than saying, "Yes, I remember that account," before you know your rights. The less you say on the phone, the more protection you give yourself. Third, if you confirm the debt is time-barred, you can choose not to pay, and the collector cannot take you to court. They may still ask, but without the legal threat of a lawsuit, their power is limited. In many cases, simply informing them that you know the debt is beyond the statute of limitations is enough to stop the calls. Facing a collection call about an old debt can make your heart race and your mind spin. But the truth is, you have more control than you think. Knowing about statutes of limitations gives you the power to protect your money, your peace of mind, and your dignity. You've worked too hard for your retirement to see it chipped away by debts that legally died years ago. By pausing, asking for proof, and refusing to be rushed, you can keep yourself safe from one of the most common tactics used against older Americans. And that knowledge is worth more than any payment a collector could ever ask from you. Type 6. Scam bills or fake companies. Imagine opening your mailbox and finding a bill that looks completely legitimate. Maybe it's for your internet service, antivirus software, a medical alert system, or even a home repair you never requested. The logo looks real, the language is formal, and there's a due date in bold letters. For a moment you hesitate, wondering if you simply forgot about this charge. That's exactly what scammers want you to feel. Just enough doubt to make you pay, without asking questions. These scams prey on trust, urgency, and sometimes the natural desire to keep our affairs in order. They might warn you that your service will be shut off within 24 hours unless you pay immediately. They might claim your computer is at risk, or that your medical alert subscription has expired, and they almost always push you toward paying in unusual ways, like with gift cards, wire transfers, or prepaid debit cards. This is a huge red flag. No legitimate company will demand payment in a form that cannot be traced or refunded. One common trick is the phantom bill scam. I recall a widower in Texas who received a $350 invoice for antivirus protection. The bill looked professional, and it even had his name and address printed clearly. When he called the number listed, the representative pressured him to pay right away with gift cards. Thankfully, he paused and called his son, who quickly recognized it as a scam. That one phone call saved him hundreds of dollars, and a lot of stress. If you ever receive a suspicious bill, your first step is to demand verification. Ask for the company's business license number or official registration. Request a written invoice that clearly shows what service was provided, when it was authorized, and who approved it. Real companies will not hide that information. Scammers, on the other hand, will avoid your questions, hang up, or become aggressive. Before you pay anything, take a moment to do a quick online search. Type in the company's name along with the word scam or complaint. Often you'll find reports from other people who received the exact same fake bill. This small step can expose a fraud before it costs you a dime. If you confirm it's a scam, report it to the Federal Trade Commission, FTC, or your local Consumer Protection Office. In many states, senior protection agencies can also step in to help stop the harassment and warn others. By reporting, you're not only protecting yourself, you're helping shield your neighbors, friends, and community from the same trap. Remember, you worked hard for your savings, and no one should be able to take that from you through lies and intimidation. Staying cautious, asking questions, and trusting your instincts are some of the best defenses you have. The moment something feels off, step back, breathe, and investigate. Scammers rely on speed and fear, but when you slow down and verify, you keep the power in your hands. As we wrap up today's conversation, I hope you're walking away with a little more clarity, confidence, and peace of mind about the bills you may not truly owe. Knowing your rights and taking a moment to question what lands in your mailbox can protect not only your savings, but also your sense of independence. And remember, when it comes to your health or any specific symptoms, always speak directly with your doctor to get the care that's right for you. These tips are shared for general awareness. If you're facing any health challenges, be sure to check with your doctor before trying anything new. I'd love to hear from you. What was the most valuable thing you learned today? Or simply drop the word hope in the comments so I know you're with me. If you found this video helpful, please subscribe, tap the notification bell, and share it with a friend or loved one who might benefit from it. Until we meet again, may your days be lighter, your mind at ease, and your heart full of the kind of hope that carries you through every season of life.